This is screenshot video 1, weeks 11 to 12 contracts. And we're looking first at Chapter 8, Performance and Discharge. And before I start walking through this a little bit with you, let's just consider a few things. We're in the area, it seems to me now, when we're talking about performance and discharge, and then our next chapter, remedies for breach of contract, where if in our hypothetical law firm we do civil litigation, we represent clients in civil litigation, particularly in commercial areas, this is where we're going to be doing a lot of thinking and a lot of work. If we're in a law firm that does more transactional stuff about contracts, then we hope to avoid most of these areas. But if we get involved, it really depends upon what the practice is, and maybe if it's a large firm, what department we're in. But if we're in litigation, this is where the food fights often begin. And so there's a practical overlay to this that I hope we can get to as we're going through this material. Let's consider another thing so that it's more than just words here. The assumption is that when we're looking at performance and discharge of a contract, that we have a valid contract. In other words, we have those 4 requirements of a valid contract. We have an agreement. We have consideration, we have capacity, and it's legal. So we also now are out beyond the concerns that can upset genuineness of assent, like mistake of fact or fraud or duress, or undue influence, or even conceivably unconscionability. And we're going to look at this contract and see how the parties' obligations under the contract can be discharged. And I've set forth and I've summarized the chapter in this posting 4 different categories of discharge. Discharge means if I'm the party, I don't owe you, if you're the other party, anything more under the agreement. And how can that come about? Well, this is what we're going to be looking at. And I'll try to come up with different types of contracts as we go through the material. So first, discharge by condition. And you obviously can read what I've posted here, but let's consider that we have a contract for the sale of real estate. And some of you may have entered into such a contract, or you have a friend or a relative who has, and you were kind of in on it a little bit. But and we have a course on real estate practice. But in any event, we have a buyer and we have a seller. And we have a written contract, I can assure you, that's been signed by both parties, because that's what the statute of frauds requires. And imagine now we're looking then at this written contract for the sale of real estate. What I'm going to tell you is when you go through it, you're going to see a purchase price, of course. You're going to see a description of the property being sold, of course. But you're going to probably encounter something known as a condition. In the condition, there'll be other conditions, but this is the one I'm thinking of. And the condition is going to be financing. And what do I mean by that? Well, most of us, if we're going to be purchasing a house, let's say, are going to need to borrow money to do so. Possibly if you're selling an existing property you own, you may make enough money from the proceeds of the sale to buy a house where you don't need to finance the purchase, but most of the time we do. Now, what that contract for the sale of real property is going to say, and again, I'll leave it to the real estate course to get into the exact language, but it's going to basically say to the buyer, you've got X number of days, 30 days, whatever, and there'll be a specific amount of days, to make a good faith application for a loan, and you can specify, and it will, the amount of the loan, and it will specify the ranges of interest. This is all negotiated. And X number of days to obtain the loan, and if this condition cannot be met, then the contract has been discharged. If you will, the parties' performance on both sides, seller and buyer, has been discharged. And we can call this a condition precedent, meaning it's a condition that must be fulfilled, obtaining the loan, before a party's performance can be required. And I identify real estate contracts as a type of contract that has this condition precedent. We could also have something known as a condition subsequent. And unlike a condition precedent, this condition operates to terminate a party's performance. Where the first one, condition precedent, really triggers the right of future performance. So let's, and I just have used myself as an example, it's hiring time for, though we're not going to do it, for recent law grads, right? Because we're at the end of, getting to the end of the school year. So what might happen, let's assume that my law office hires a recent law graduate, and if they're just graduating, they haven't taken the licensing exam, the bar exam. So we may have an employment contract. I think this is what I would want, that our obligation to continue employing this newly graduated attorney is discharged if the attorney fails to pass the bar exam. Because what I don't want is the person failing the bar exam and thus not being of use to us as an attorney to practice law, and still having an obligation to continue them as an employee. I may want to do that, but then if I did it, I'd want to do it under a new contract with different compensation, etc. So that would be a condition subsequent. So we've got condition precedent, condition subsequent, and we can then have thirdly concurrent conditions, and this is the last set, if you will, of conditions. And this is where if the parties expressly or impliedly are required to perform the duties simultaneously. I'll give you a concurrent condition. After I dictate this, I'm going to go to Wegmans and buy groceries, and really the deal is at the checkout line, I get to keep the groceries or get to take them with me if I pay Danny Wegman the amount on the bill. So that gives us a sense of discharge by condition. I think the one you're going to run into that if you're going to be in a transactional mode as a lawyer or paralegal will be the discharge by condition precedent, the real estate deal, and possibly if you're doing employment contracts, especially if there's licensing involved, condition subsequent. But traditionally we talk about concurrent conditions as well. I wouldn't be too concerned about that other than being able to identify them. So that's the first category. Now we have one that is meatier and is going to take more time to get through, and that is a discharge by performance. And as the authors in the book note, most contracts are discharged by performance. And let's hope that if you and I are parties to a contract, that we both discharge our obligations by performance. I do what I'm supposed to do under the promises I've made to you, and you do what you're supposed to do under the promises you made to me, and we have discharge by performance. Where it gets a little bit, not dicey, but where we've got to dig a little bit is when we identify complete performance and substantial performance. Complete performance is not a problem because this just says that there's no question that a contract has been performed. You hire a lawyer to represent you when you purchase the house. After the purchase is completed, the lawyer's duty under the employment contract is discharged. And by the way, your payment of legal fees, thank you, discharges your obligation to the lawyer. Both of you have engaged in complete performance. Substantial performance is a little bit tricky. When we used to have classes, remember that? A case I loved to spend time with was Jacobs and Youngs versus Kent, because it brings up this idea of substantial performance. And in that case, and I encourage you to take a look at it in the book now, you've got a contract between a property owner who wants a house built and a builder who's going to build it for the property owner. And if you've ever been involved in that type of contract, you know that there's specifications for the type of stuff that's going to be put into the house. You know, are we going to have wood floors? Are we going to, or laminate, et cetera, et cetera. This was a fussy owner. He wanted a particular brand of pipe to be used for the plumbing. And the builder didn't install the brand of pipe. There was one was Cohos and I forgot what the other was now, and I don't feel like looking it up because I want to keep on moving. But there was a different brand of pipe used. The only difference between the two brands was what was stamped on the pipe. That might not always be the case, but in this case it was. In other words, other than what was stamped on the pipe used in all other respects was the same quality as the pipe that should have been used. And the owner says to the builder, I don't care if it's the same type of pipe. I wanted a certain brand. You didn't use it. You haven't discharged your obligation to me because you have not rendered complete performance. And quite frankly, I'm not going to pay you until you do. And if you think about it, what the owner was saying to the builder was, well, you better tear out the pipe you've installed and put in the different pipe. And you can imagine what the builder is saying. The builder is saying, but it doesn't really matter. And if you think about it, presuming that the proof establishes that it's the same quality, it really doesn't matter other than the difference in brands that are called for. And there's no aesthetic deal because, as you know, one of the terrible things about a leaking pipe in your wall or ceiling is that you can't see the pipe until you break open the wall or you break open the ceiling, meaning that how the pipe looks doesn't add or detract from the aesthetic quality of the house. The court said in the case, and I'm sort of generalizing a bit, but the builder was entitled to the contract price for building the house so long as the builder could show, as he claimed to be able to show, that it was of the same quality of pipe. Under that approach, where we don't have complete performance, we have something known as substantial performance. And the court went further and said, and the court said, if by any chance you, the person who received substantial rather than complete performance, can show that there's some kind of damage you incurred because of it, you can recover it. If you think about it, that would rarely be the case. And so, as I point that out in the pipe case, it is difficult to imagine how there were any damages. Now, when we're looking at performance, we can take our first look at what does breach of contract mean. In the next chapter, we'll talk about remedies for breach of contract, and I think I'm going to suggest something about remedies in the next thing we're going to look at, which is time and performance. But what we can say, and I think this is key,